Hi colleagues, Scott Solkoff coming at you from Delray Beach, Florida, and I'm going to talk to you today about Florida's new power of attorney law that went into effect just this past October 1st, 2011. It's the biggest change to power of attorney law that we've had in Florida since 1995, so it's a pretty big deal, and it has required a change to all of our documents. And I'm going to share it with you both for out-of-state lawyers who have clients that sometimes come to Florida, and I'm going to share it with my colleagues in Florida for some ideas on drafting issues. And if you're not a lawyer, you can still watch this, but don't try this at home. Now, I'm going to speak to you today because this is kind of a big deal law, new changes, and a lot of it. I'm going to have to use my notes. So from time to time, if I look down, don't be offended. I'm going to run through some of the bigger changes, but these are all found at Chapter 709, Florida Statutes, and I'm going to run through them fairly quickly. We're only going to do a few minutes today. Revocation has never really been dealt with in Chapter 709 specifically. We know that a power of attorney can be revoked by the principal, but there is very little guidance on how. Now the statute reads that the principal may revoke a power of attorney by either an express revocation or by doing a new power of attorney, and in that power of attorney revoke the prior powers, which normally wasn't done in Florida before. It wasn't the practice, but now it will be. The principal's signature is the only legal requirement for a standalone revocation. If we're going to do a revocation as part of a power of attorney, the execution requirements really require two witnesses and a notary. But a standalone revocation would be on the principal's signature alone. Suspension and termination. In all cases, the termination or suspension of a power of attorney is not effective as to any agent who's acting in good faith. And this has always been the case. It's not a big change in the law. Even if that power of attorney is acting without knowledge, the attorney in fact is acting without knowledge of the suspension or the termination, it's still valid. One of the biggest changes to the power of attorney statute is that, we now no longer have springing powers of attorney in Florida. So it means that I cannot draft a power of attorney that says that this power is only effective upon my incapacity or upon such and such a date. Powers of attorney in Florida must be effective upon signing, always. Now, we can include language that terminates the authority, but the authority must begin upon signing. So those powers of attorney that were springing, legally valid before, prior to the effective date, October 1st, 2011, are still valid and can be springing. They'll still be recognized. That's a big change in the statutes. Springing powers of attorney from other states will not be, will have at least very great difficulty being honored in Florida. The agent. Unless the power of attorney provides otherwise, each co-agent now, if I appoint more than one attorney in fact, under current law, under prior law rather, the attorneys in fact must have acted in unison or a majority vote if there were more than one. Unanimous if it was two, majority vote if it was three or more. And so now that's changed completely. And a big change is that the default, if we say nothing in the power of attorney, the default is that each attorney in fact may act independently and without the signature of the other. Now, even where the power of attorney expressly requires two or more agents to act, there's an exception, an important exception in the statute that was got in by our banking friends. And that is that there is a special exception for banking transactions. So that even if I expressly require two or more of my agents to agree before any transaction is done, that will not apply to signing checks and otherwise handling banking matters as provided at 709.2111 sub 6. Now, what that means is if I appoint more than one attorney in fact, they can agree together. The non-acting attorney, in fact, can say, my sister in Florida, I'm up in New York, my sister in Florida can go ahead and act for me. And I can, in writing, give that delegation of authority to my co-attorney in fact to act without me. Now, that delegation must be expressed by the non-acting attorney in fact. But that's a big deal, a big change in Florida. Now, the statute is silent, and here's a matter for drafting and thought. The statute is silent on whether or not I can draft around that. Can I say as grantor that I forbid the delegation? We don't know yet. Probably. Resignation. An agent who wishes to resign may do so by either complying with the requirements for resignation that we put in the power of attorney, or must give notice as provided now in the statute. And the statute requires that notice be given to the principal, if the principal is competent. If the principal is not competent, to that principal's guardian, court-appointed guardian, to any co-agent, or to any successor agent, and to any successor agent. Now, if you're a drafter, you may also want to include in that, even though it's not required by statute, to add the requirement that the resigning attorney, in fact, notify any of the financial institutions, the known financial institutions. That could be important depending upon how you're drafting.